In this section, we will cover important information about resident representatives and their authority, including who can be appointed as a representative and who cannot, the role of the representative, and the authority they can be given, how authority can be given in a power of attorney, and a representative's duties and obligations. Who can the resident appoint as a representative? A resident can choose any trusted individual to serve. Who may not be appointed? The following persons may not be appointed as a resident representative unless they are also the resident's spouse, state-registered domestic partner, parent, adult child, brother, or sister. Any of the resident's physicians or the physician's employees, or the owners, administrators, or employees of a healthcare facility where the resident resides or receives care. Can a resident appoint more than one resident representative? A resident can appoint any number of co-representatives that meets the resident's needs, such as one for healthcare and a different one for finances. A resident can require that they share responsibilities equally or not, and the only limitation is the resident's needs and desires. The resident can also appoint one or more successor representatives who can assume responsibility if a primary representative is unavailable, unable, or unwilling to act on the resident's behalf. It is important to read and review a power of attorney to identify any and all co- or successor representatives and the authority that they were each given by the resident. What is the representative's role? It is important to understand that the mere appointment of a person as a resident representative does not legally obligate that person to accept the appointment or take any action authorized by the power of attorney. But if the representative accepts appointment, is available and willing to make decisions and take actions on behalf of the resident, then any decisions or actions must be consistent with the authority given by the resident in the power of attorney, subject to the duties and obligations required of the representative by law, and consistent with the guarantees in the resident rights law. What if there is a conflict between representatives who share decision-making authority? Where a power of attorney appoints co-representatives and provides equal authority to each, it is important that the representatives collaborate and reach agreement before making any decisions. In the case of a conflict, facility staff may not simply choose to favor one or accept the authority of one representative over another. A representative with capacity has the right to choose among the representatives or make the decision independently. Regardless, it is important that long-term care facility staff act to ensure that the residents' rights are protected and that the residents' expressed choices and desires, written, verbal, current, and historical, are respected. Once again, administrators may choose to exercise discretion to seek legal advice in situations where there is a conflict that cannot be resolved by the resident. Additionally, your long-term care ombuds is knowledgeable about residents' rights law and is available to provide information and support the resident in such situations. What if there is no representative, co-representative, or successor representative available or willing to act? And this can present a potentially complex problem, but only if the resident is unable to make the required decision or take the required action. Because regardless of the power of attorney, the resident retains independent right to make those decisions and take those actions concerning their health care, lifestyle, preferences, and choices. Where the resident lacks capacity, there is at least a potential solution available for the limited and specific purpose of obtaining informed consent for health care. Washington state law affords the possibility of relying on a specified group of individuals that could provide the necessary informed consent. The discussion of the available process is beyond the scope of this presentation, however. Additional information about it can be found in the reference guide. What can a resident authorize a representative to do? Well, generally, a resident can give authority to a representative for any lawful decision or action that the resident could do independently. The resident representative may not, without the resident's consent, commit the resident for mental health treatment, therapy, or other procedure that induces convulsions, surgery solely for the purpose of psychosurgery, and that is lobotomy, other psychiatric or mental health procedures that restrict the resident's freedom of movement, or placement in a residential treatment facility that provides nursing or other care. And yes, this does mean in a long-term care facility. And what exactly has to be written in the power of attorney? Well, the power of attorney must contain the actual authority the resident intends the representative to have. Importantly, the law requires that certain types of decisions be explicitly authorized. And included in those types of decisions are the ability to delegate authority given by the power of attorney or to give informed consent for healthcare-related decisions. The complete list of the types of decisions that must be written can be found in your reference guide. It is important to read and review a power of attorney to determine the extent of a representative's authority to make decisions on behalf of the resident. And for example, the facility should at least determine that at a minimum, the power of attorney authorizes the representative to provide informed consent for healthcare decision and access and release resident healthcare information. Here we need to discuss another effect of the recent change in law governing powers of attorney. And I caution you this change can be complicated to understand in this brief presentation. It is recommended that you take time to review the additional information that is available in the reference guide. This change allows for a simplified way of making a general grant of authority to a representative. And it also amends the law to include full descriptions of representative authority for certain types of decisions. The law refers to those types of decisions as descriptive terms. This change is very important. Why? For any power of attorney executed on January 1, 2017 or thereafter, if the power of attorney contains a grant of general authority using general language, such as, my representative has authority to take any action that I am legally able to do myself, or to do all the acts that I could independently do, or words of similar intent, then the representative receives general authority to make decisions concerning anything that is described in the entire set of descriptive terms that are found in the new law. Some of the descriptive terms that are likely relevant to a resident in a long-term care facility are listed on the screen. Real property, tangible personal property, banks and financial institutions, military civil benefits, retirement benefits, deferred compensation, and notably, healthcare is included in that list. The complete and current list can be found in the available reference guide. The prior law, by the way, contained only two descriptive terms, real property and tangible personal property. And if the power of attorney gives the representative authority with respect to a single descriptive term, then the representative receives authority to act with respect to any matter that is covered by that specific descriptive term. In either case, no further language is necessary. The power of attorney can have qualifying language that adds or subtracts from the authority that is given in any descriptive term. If you are presented with a power of attorney executed on or after January 1, 2017 that has a general grant of authority or has references to descriptive terms, it will be necessary to read and review the descriptions of authority that is found in the law in order to fully understand the authority the resident's representative has been given. Why the change in law? Perhaps to make drafting a power of attorney easier, but it can make your task of understanding what it authorizes more difficult. Again, a link to the new law can be found in the appendix to the available reference guide. What duties and obligations does a resident representative have? The representative owes a significant number of duties and obligations to the resident. They include and not limited to the following: to act in good faith, loyally, and for the resident's benefit, consistent with the authority granted by the power of attorney, to exercise care, competence, and diligence when engaging another person on behalf of the resident, to never delegate authority to another person unless it is specifically authorized by the power of attorney, and then to exercise care, competence, and diligence when selecting and monitoring that person. A fiduciary relationship concerning the resident's finances and property, to act in accordance with the resident's reasonable expectations if they're known, and when they're unknown, to act in the resident's best interest. Can a resident representative override a resident's decision? Generally, the answer is no. A resident does not surrender independent decision-making authority simply by executing a power of attorney. Additionally, a resident with capacity can revoke a representative's authority to make a particular decision at any time. And even where a resident lacks capacity to make a decision, the representative is obligated to act in accordance with the resident's reasonable expectations if they're known. And if those expectations are unknown, then the representative must act in the resident's best interest. What responsibility does the representative have where a resident lacks capacity or that capacity is in question? A representative has the same basic responsibility as when a resident's capacity to make a particular decision is not compromised: to act in accordance with the resident's reasonable expectations when they're known, and to act in the resident's best interests when those reasonable expectations are unknown. I've mentioned the situation where the resident's reasonable expectations are unknown, so let's take a closer look at the representative's responsibilities there. Where the resident's reasonable expectations are unknown, whether due to a lack of capacity or the inability to effectively express and communicate choices and desires, the representative should always choose what the resident would do if the resident was competent and aware of all the circumstances, including the effect of the lack of capacity, to give substantial weight to the resident's current stated desires and wishes, as expressed through past statements, practices, information shared with others, and observations, to seriously consider resident behavior and verbal expressions, as they are both a form of communication, to consider the opinions of professionals, relatives, and friends with knowledge of the resident, to seek independent professional evaluations and opinions to support decision-making, and only after those options have been exhausted, make a decision that is in the resident's best interests.